speak for God. Give us your tithes or your soul will burn.
We speak for the law. Give us your retainer or your life will be ruined.
The American accusatorial system has been replaced by an Inquisition wearing its clothes.
The grand jury, meant as a shield, has largely disappeared.
99.5% is the actual overall conviction rate of the United States federal court system. When a hedge fund manager guarantees a 99.5% return on investment year after year, the financial world identifies it as a Ponzi scheme. Mathematical perfection in a human system is the signature of a scam. Out of nearly 72,000 defendants processed in a year, almost every single one is convicted. The Constitution imagines a trial as a complex, unpredictable ecosystem. It relies on independent agents, a jury, an adversarial defense, and a neutral judge, searching for the truth in a dynamic environment. Over the last century, the state dismantled that ecosystem and replaced it with a highly complicated, deterministic machine. The system uses millions of procedural wires and dials to ensure the plane lands exactly where it was programmed, at a conviction. This near-total conviction rate is the output of a closed-loop assembly line. The process is mathematically engineered to remove the only variable that could lead to an acquittal, the presence of a functional defense. The assembly line begins with the grand jury. Historically, this body functioned as a citizen shield. During Prohibition, grand juries routinely looked at government evidence and returned no bills, rejecting the state's case roughly 25% of the time.
2010, federal grand juries looked at 162,000 cases and said no to just 11. That's a 99.993% win rate for the prosecutor. If a casino won 99.99% of blackjack hands,
used to reject 1 out of every 4 cases.
About a 25% no bill rate.
That was the citizen shield. It was a real check on overzealous prosecutions.
Fast forward, prosecutors run the room and no bills have dropped to less.
In civil court, lawyers get paid only if they win, so they swing for the fences.
Hundreds of hours, depositions, discovery.
But in criminal court, contingency fees are banned. The lawyer has to take a flat fee up front and the math flips.
10 hours on a plea can net $1,000 an hour, $200 plea rate.
Phase 3 is what we call the trial trap, how the so-called speedy trial turns from shield to sword.
For the first 90% of a case, the defense lawyer does nothing but read the state's story and nudge the client toward a plea.
Then, if that client says, no, I want my day in court, the clock becomes a weapon, and it's the same trial sentencing, then there's no advance.
Phase 4 takes us past the verdict into sentencing and appeal, where the system cashes in again.
If they win at trial, billing stops. If they lose, they stage a dramatic closing, sell the client on how hard they fought, and roll that client straight into the next pay cycle.
The grand jury was meant to be a citizen shield. Today, it indicts in 99.9% of cases. When prosecutors handpick the evidence and the defense is barred.
This graph tracks that historical shield as it collapses. Today, the refusal to indict rate has dropped to less than 1/10 of 1%.
Citizens aren't the accusers anymore.
In legal history, the shift from accusatorial to inquisitorial is about one thing: who holds the power to accuse? In the accusatorial model, the victim or the peers bring the charge. The state simply referees.
The modern grand jury operates as a covert inquisition. With the defense banned from the room and the evidence one-sided, guilt is structurally predetermined behind closed doors. The citizen check has flatlined, ensuring nearly 100% of indictments feed the conviction pipeline.
Speak for God. Give us your tithes or your soul will burn.
A federal grand jury sits for 12 to 18 months, which automatically filters out hourly workers and small business owners due to financial hardship.
Think gerrymandering, but for data. Instead of drawing district maps, they draw data lines inside jury software. They own the tax, census, and FBI files, and they own the wheel that picks the juror.
Jurors are often retirees or government employees. The prosecutor is pitching a case to an audience whose paychecks are signed by the state. In the case United States v. Williams, the Supreme Court ruled that prosecutors are not required to show the grand jury exculpatory evidence. The state can hold a document proving a defendant's innocence and legally hide it while asking for an indictment. Once indicted, a defendant encounters the economic paradox of criminal defense.
We demand the full contingency. This case requires thousands of hours of work.
It's a flat fee. Take the deal now, and you're done in 10 hours.
The Bar Association explicitly bans contingency fees. The system is locked into a plea factory.
Federal indictment with 10 defendants, the state doesn't want 10 trials. It wants 9 deals so it can use them to crush the one. The guild now calls a lawyer good when they land a quick plea. That keeps the judge happy, the fee intact, and the prosecutor.
Where 89.5% of federal cases end in a surrender before a trial ever happens. Defense attorneys survive this conflict of interest by adopting a specific psychological defense. They default to trusting the prosecutor's narrative, giving themselves the moral permission to surrender while still collecting the check. The hired shield is economically weaponized against the citizen. In this architecture, the defense attorney is incentivized to act as the state's negotiator rather than the defendant's advocate.
The system hands me a story to tell myself. I went to law school to fight for justice. Instead, I'm shoving people through a plea mill. Every file feels like another life I don't have the time to battle for.
In this house of justice, 99.6 isn't just a number. It's a narcotic, a moral excuse the guild uses to sleep at night. When 9 out of 10 people plead out, it's the illusion of inevitability. It's the numbers that high, no one wants to be the error in the spreadsheet. So the gears turn, the stamp comes down.
For the few who demand a trial, the speedy trial rule becomes a tactical sword.
I'm saving them, but the loop keeps turning. Grand juries rubber stamp the charge sheet like it's a secret right. Trial becomes a gamble I can't let them take. The flat fee keeps my hours on a leash, and the invisible tax is paid.
It forces the defense into the arena against an FBI investigation that has been running in secret for years. The citizen starts from zero, while the state's clock is already at the finish line. Prosecutors then employ charge stacking, burying a defendant under distinct counts for the same act. To walk free, you must perfectly defeat every reel. This ensures a partial verdict, where a single guilty count still results in prison.
Flashing cameras, headlines, and a careful split verdict. The show keeps us tuned in while the system stays intact. Then there's Luigi Mangione. No champagne, no red carpet. He went after a healthcare CEO.
Because of this math, the per-defendant conviction rate at trial remains between 95 and 98%, the U.S. v. Watts precedent. It allows a judge to increase a prison sentence based on acquitted conduct, the very acts the jury just found the defendant not guilty of. Even when a citizen technically wins in the courtroom, the procedural math is designed to ensure they still lose their life. These individual procedural gears form a successful deterministic empire. The machine is operating with the precise efficiency it was designed to achieve. The system occasionally orchestrates systemic theater to protect its image. High-profile no bills for politicians or elites create headlines that suggest the grand jury is still independent.
A federal grand jury has declined to indict 6 sitting members of Congress, rejecting the Justice Department's case.
Your Honor, the grand jury's a rubber stamp.
Really? They just tossed the case against 6.
These anomalies manufacture legitimacy for a system that rubber stamps the other 99.9% of indictments.
In a normal grand jury, the prosecutor hides the good stuff. Indicting is easy, even a ham sandwich. But when 6 members of Congress are on the board, everything flips.
Absolute immunity to prosecutors and judges because they are the mechanics of the 99.5% machine. This immunity ensures the assembly line is never threatened by the citizens it processes. The American accusatorial system has been replaced by an Inquisition wearing its clothes. Recognizing that you are facing a pre-programmed assembly line is the necessary first step to surviving it.
4 principal information biases that shape news presentation are personalized news, dramatized news, fragmented news, and normalized news.
Normalized news thrives on sensationalism and conflict. It prioritizes entertainment over analysis, exaggerating events to perpetuate fear.